How do AI model licensing agreements work? Imagine you've built a powerful artificial intelligence model that can generate images, write stories, or analyze data. Now, you want others to use it, but how do you make sure everyone plays by the rules? That's where licensing agreements come in. These are legal contracts that spell out exactly how your AI model can be used, who owns what, and what each party is responsible for. The agreement starts by clearly naming the licensor, which is the person or company that owns the AI model, and the licensee, who gets the right to use it. It also states when the license begins, so everyone knows the exact date the agreement kicks in. There are different types of licenses. A non-exclusive license means you can give the same AI model to many licensees at once. An exclusive license means only one licensee can use the model, often for a higher fee. A sole license allows the licensee to use the model, but the licensor can still use it too. Most licenses are non-exclusive because they let the owner license the model to multiple users easily. Next, the agreement covers payment terms. This could be a one-time fee, a subscription, or a fee based on how much the AI is used. Some licenses charge per API call, which means every time the model is used, a small fee is paid. Others might have tiered pricing, where costs increase as usage grows. Sometimes, royalties are paid as a percentage of revenue made from using the AI. The agreement will specify when payments are due, what happens if a payment is late, and any other financial details. Ownership of the AI model itself usually stays with the licensor. But the agreement can also specify if the licensee owns certain parts or if rights are shared. It is also important to clarify who owns the outputs created by the AI. For example, if the model writes a story or creates an image, does the licensee own that content? Or does the licensor keep rights to use those outputs? Sometimes, ownership is shared, or the licensor keeps rights to use the outputs to improve the model later. Training data is another key point. The agreement should state who provides the data used to train the AI, who owns it, and who owns any improvements made to the model. If the licensee adds new data, it could unintentionally help improve the model for others unless the contract specifies otherwise. Usage rights are also covered. The license will specify where and how the AI can be used. For example, it might be limited to certain countries or industries. It can also restrict copying, modifying, or sharing the outputs or the model itself. Liability and warranties are included to protect both sides. Usually, the licensor limits their responsibility for errors or inaccuracies in the AI's results. The agreement should also clarify who is responsible for complying with laws related to data privacy, intellectual property, and AI use. Finally, the agreement explains how either party can end the license and whether rights can be transferred to others. Many agreements requiring prior approval before transferring rights to third parties. In the world of digital content and AI-generated outputs, these agreements help clarify who owns what and how the content can be used. They protect the rights of the model owner while allowing licensees to innovate and deploy AI solutions confidently. These contracts are essential tools for managing rights, responsibilities, and risks when working with AI models and their outputs.